Good morning. I'm Bonnie Gardner. I'm co-chair of the Public Affairs Forum of the First Unitarian Universalist Church of Austin. Our forums are free and open to the public and are most Sundays at noon. We encourage you to attend. For more information about our forums, you can go to our church website at www.austinuu.org. Today, I'm honored to introduce Gary Cobb, who's going to be speaking about the grand jury, somewhat mysterious to many of us, and he is a serious expert on many criminal justice issues. He has been Assistant District Attorney for a number of years here in Austin, Travis County, and he's now running for District Attorney, certainly well prepared for the job. Let me tell you a little bit about Gary's background. He's a native of Mississippi, went to Mississippi State U and then University of Texas Law School, graduated in 1986, first worked with the Texas Youth Commission, that is a tough job, as a senior hearings examiner. Then he worked for the municipal court as a prosecutor, but he really found his true calling as a felony prosecutor with Travis County in the DA's office, and he joined that office in 1990. He has trained, supervised, mentored countless young attorneys and prosecutors. He is also a teacher or professor at UT Law School. He's lectured for the Texas District and County Attorneys Association, the Austin Criminal Defense Lawyers Association, and he's been on the faculty of the National District Attorneys Association. He has many very serious responsibilities in his job, and he's really done an outstanding job for many years. He's also in his community a volunteer in a variety of organizations, including the Men and Boys Conferences and the Council on At-Risk Youth. Gary and his wife, Nichelle, live in South Austin, and they're the parents of two boys, Aaron and Keenan. Gary, thank you so much for sharing time with us, and let me let you get to what's important now.
Great, thank you. What I want to do today is to give you an understanding about the grand jury process. Here's something I've learned over the last year or so is that everybody hates the grand jury, but nobody understands what the grand jury does. People have very little idea about what this great institution that we call a grand jury does. So I want to talk to you about some legal concepts that will help you understand where the grand jury system fits in. Also, I want to talk to you about some history and how the grand jury got started, how it ended up being something that's even in our United States Constitution and in the Texas Constitution. Then I want to talk to you about the grand jury in modern-day Texas, and finally about some recent changes, dramatic changes in how grand juries are selected and what that means for our community, because I think it does have, there will be some huge changes in how cases are handled by the grand jury. And I want to end it, if we have time, with a little bit of trivia. If you can figure this out. If I go through something and I'm a little bit obtuse about it, as sometimes lawyers can be, feel free to stop me and ask me about it. A lot of this I may get to eventually, so if you want to hold your questions to the end, that very well may be better. I'm the director. I supervise our grand jury division with the Travis County District Attorney's Office. I've been doing that for about the last 4 years, I think. I've been with the DA's office, Bonnie said, a number of years, Well, that number is 2.5 decades, so I've been there for a large number of years, frankly, and have handled a great many different kinds of cases over the years. So the first thing to understand about when you're dealing with law in general is that law is basically broken up into two different areas. There's civil law and there's criminal law. Civil law and criminal law. Civil law basically has to do with money. Someone suing somebody for money. So for instance, if you're in a car accident and someone has hit you and caused injury to not only your vehicle but also to your person, and you might want to recover the damage to your vehicle and also the pain and suffering and lost wages and things like that, then you might have to sue the person if you can't reach a settlement. That's what civil law is about. Nobody goes to jail because of civil law. You might end up paying a lot of money. Civil law also has to do with rights, the enforcement of rights. Classic example is we just recently saw a Supreme Court decision saying that marriage equality is now the law of the land. That's a civil issue. It has nothing to do with crime, even though in a lot of states activity related to homosexual conduct was once criminalized, but it no longer is. The court long ago said that illegal to do, it violates equal protection. So the opposite side is criminal law. Criminal law does have to do with people occasionally, often going to jail in this country. Bunny mentioned about the mass incarceration. Folks don't often realize that in the United States of America, we incarcerate more people than anywhere else on this planet. And I think we now realize that's not the best way to handle crime. If you have really violent people, that's the best way to handle crime, but most people really aren't that violent, so we have done that. Just to get off a little bit on a side topic. Okay, so Travis County DA's office only deals with felony cases. To understand the difference between felony cases and misdemeanor cases, you have to understand the difference between the Andy Griffith Show and a show on HBO. It used to be on HBO. I'm sure it's in reruns now, called Oz. Oz is a show about the going-ons in a prison. I think most folks here know about the Andy Griffith Show. So the DA's office only handles felony cases. So what's the difference between a felony case and a misdemeanor case? The way to easily think about it is think about the possible punishment if someone is convicted of a felony versus being convicted of a misdemeanor. If you are convicted of a misdemeanor, you end up in a local jail, like from the Andy Griffith Show. Remember the lovable drunk Otis was always getting arrested, and usually he could let himself out of jail once he sobered up. Misdemeanor cases, if someone is convicted, the highest possible punishment is up to a year in the local county jail. We have a jail out at Del Valley. We will have one downtown right at the Criminal Justice Center. So the doesn't mean a person will go to jail, but the highest possible punishment is up to a year in jail. For a felony case, it's more like Oz prison type. A person could be sentenced to a big prison, a rough prison. We have prisons scattered all over the state of Texas. Possible punishment is up to from 2 years up to life in prison, depending on the type of felony the person is being convicted of. Or we also have the death penalty here in Texas, so a person could forfeit their life. Those are felonies. Remember, misdemeanor cases only get sent to the local jail, like with Barney. Felony cases, a person could be sent to prison for up to life in prison, or could receive the death penalty. Everybody clear on those distinctions? So here in Travis County, our DA's office only considers felony cases usually. There are some exceptions to everything, so there are exceptions under the law where the Travis County DA's office has jurisdiction over some cases that are misdemeanor cases. What does the grand jury do? The grand jury basically says, in making a decision, and we'll go later, we'll talk a little bit more about that, that we, your fellow citizens, have received sufficient information from some source. And based upon that sufficient information, we believe that you have done something that violates the laws of our state. And based upon that, we're going to give you this paper so you can look at this paper and see what we're accusing you of doing. That paper is called an indictment or a true bill. But that's basically what a grand jury does, to give you an overview of that. Now, there are different kinds of grand juries. There's a federal grand jury, which typically has 16 to 23 members. And the federal grand jury, 12 members must concur in an indictment. Now, who makes up the grand jury? just citizens of a certain district or area. When you're talking about the federal grand juries, it's whatever the citizens from we would be in the southern district, I believe, is what Travis County is in. So everybody within the multi-county region could be called to serve on a federal grand jury. For a state grand jury, and all the states are not required to have a grand jury system. Many states do not have a grand jury system. All states have something in their provision about the grand jury, but many have abandoned it. Only about half of the states actually employ grand juries for any purpose. 23 of them require to varying degrees. Texas is an exception in that any kind of criminal felony case, it requires a grand jury action. Every state does not have the same requirement. Some states allow other ways of presenting cases rather than the grand jury. If not by grand jury indictment, the case may be presented by what we call a complaint or an information. In the state of Texas, if it's a misdemeanor case, remember where Barney goes to jail, it's that kind of low-level case, the county attorney simply needs to file an information or a complaint. That's how misdemeanor cases are handled. Not so with felony cases. Or you can have what you call a preliminary trial. That's how it's done in many states. It's kind of like a mini trial, and then a judge is there, and a prosecutor is there, a defense attorney is there, and the judge decides if there's enough probable cause to proceed with the charges of what the citizen has been accused of. That's not how it's done in Texas. Examining trials are kind of like preliminary trials. Texas has a way of allowing examining trials, but if a grand jury takes action on it, then examining trial never occurs, and typically a grand jury takes action. So it's good to know that that's available in Texas, but rarely used in Texas. So those are the different options if a case doesn't go to a grand jury. But remember, in Texas, all felony cases must go to the grand jury. This is Job. Remember Job from the Bible? Job was the person who, between a wager between God and Satan, Satan was trying to prove that Job, who had received so much, would turn on God and would curse God. So all these different, basically personal plagues were visited upon Job. Now, why is Job important, and what does Job have to do with an indictment? Even in biblical times, the idea of having a formal accusation, an indictment, something on paper, was talked about, and it was talked about in Job. When Job was suffering so much and wondering what was it that he had done that had caused him to, after being so fortunate all his life to receive all these misfortunes, Job yelled out, "Oh, that I had someone to hear me. And I sign now my defense. Let my accuser put his indictment in writing." Job is saying, tell me what you're accusing me of doing so I can show you that I did not do anything, that I am indeed blameless. And he says, surely I would wear it on my shoulder and I would put it on like a crown. So Job is saying, if you have charges against me, bring those charges to me, put them in paper. So even in biblical times, we have this idea of, if we're going to be charged, bring that indictment on. Okay, now, how did the grand jury itself get started? Think about, 12th century England. 10th century England, 1100 and something. King John II. So at this time, there was all these conflicts going on between the church and the state. And often we have these sea changes in our society because of conflicts between church and state. Well, John II wanted to take power away from the Catholic Church. The Catholic Church kind of acted as an independent nation, basically. It had its own laws, its own rules. It owned a lot of land, had a lot of riches, did not need the King of England. The King of England wanted more power. Imagine that a king wanted more power. The King John was having these conflicts with the Catholic Church all the time. And he was also having conflicts with the people of England, who were starting to get the idea of maybe the king is not so unerring in what the king does. Maybe we should not always give everything we have to the king, including our lives. Maybe we have more value. So the people were starting to grumble a little bit about all of that. So in response to that grumbling, and also to consolidate power within the state and take it away, King John II convened what was called the Assize of Clarendon. Assize basically means a session, a meeting. So this Assize of Clarendon was him having the landowners, the knights, and the feudal lords come together, and they basically came up with this system of when someone was charged with an offense against the king, what we would call against the state now, that person would be formally charged by other citizens. So the other citizens would form an investigative body in their district, in their village, in their region. And that investigatory body would come forward with the accusations against the person, not try the person for the offense, but come forward with the accusation. So the king would appoint the people who would do this, and those people acting at the king's bidding would decide who should be charged with the offense. But you can see how having that authority to appoint these people gave you a lot of control over what was being done. So the king was using this Assize of Clarendon to consolidate the king's power. So the way it worked was they decided that 12 knights within a region would meet together and decide based on their investigations who in that region had been committing these certain offenses. And basically it was murder-type offenses, arson, theft-type offenses. These what we all recognize as crimes that we see here today. So these 12 knights, and if 12 knights weren't available in the region, it would be 12 land-owning men of the region. And so the accusers, being the knights or the 12 land-owning men, would say anyone charged before the king's justices. And all these were the king's justices, not elected folks. They were people appointed by the king. Offenses such as murder, theft, robbery, malicious burning, what we would call arson. On the oath of the 12 knights, they would be charged, or on the oath of free and lawful men, those landowners. Now, so what happens after these accusations are made against a person for murder or arson? You would think that after this, what they call a grand jurat, and grand because it was often a large group compared to one person making an accusation. What would happen afterwards? You would think a trial would happen afterward like now. But they didn't have a concept of a jury trial back then. So the accusation would be made by these 12. Why the number 12? Just because in society 12 always has this significance, the main significance being the number of disciples. So 12 was a number you often used when you just needed to set a random number. So what would not happen would be a trial after this accusation was made. So they would, 12 knights would get together, 12 lawful men, and say, I accuse this person from our village of committing arson or committing murder. And then they would have to have a way of deciding. So now one case that was very important because it showed the citizens deciding that they would not necessarily be tools or instruments of the king. So we have this famous case involving the Earl of Shaftesbury. The Earl of Shaftesbury, the king wanted him to be charged with high treason. So the jury, this group of citizens who met, decided that in this particular case, they wanted to consider the evidence against the Earl in private. Didn't want to do it in the king's court, which was always the way it was done. Well, the king said, no, we're not going to do it that way. We're going to have it out in the open. So the grand jurors, they heard this information out in the open. Then they decided they wanted to examine the witnesses in private. And the king's folks agreed to that, to allow that examination of the witnesses be done in private. Then in private, after examining these witnesses, they made the decision, they returned a bill of what they call an ignoramus. It doesn't have the same meaning today that it had back then. Ignoramus back then basically meant we don't find enough evidence. The evidence is lacking to charge the Earl with treason. And in the writings, it talks about how the people fell a hollering and a shouting, not in anger but in joy. It turned out historically the Earl was a very popular person. And another thing to keep in mind in this case where the people were going against the king's wishes and showing some independence was the people were appointed by the sheriff. Grand jurors were appointed by the sheriff. The sheriff worked for the king, but this sheriff was a little bit independent. This sheriff actually liked Earl Shaftesbury, so he appointed people on the grand jury who the sheriff thought would be favorable. One of the big criticisms of our grand jury system recently has been it's what they call a pick-a-pal system. The judges pick their pals, and their pals get on there and decide what to do, basically working at the bidding of the judge. My experience has been that is inaccurate and unfair to people who serve on the grand jury, but that's the public perception. But you see, even early on when this system was getting started, there was that kind of favoritism going on, and it worked to the Earl's benefit. So you see where these people, it was all set up because the king wanted to have more power. Ultimately, the people started little by little whittling away in England the king's power. So I talked earlier about what happens after a grand jury decides that a person is going to be formally accused of these charges. You didn't have a trial. What you had was the people put it in God's hand. They put it in God's hand. You had trial by ordeal, or you had trial by battle, or you had trial by compurgation. Compurgation is the easiest because it's a swearing match. If someone accused you of burning down someone's barn, you just got some of your trusted friends to swear that you didn't burn down the barn. And it wouldn't be a trial about it. The officials would look at it and go, yep, these are good, outstanding people. I believe these people, and that's it. That's compurgation. The other one, trial by battle, is pretty easy. If you were accused of something, you got a champion to go fight against the champion of the person accusing you. And then whoever champion won, that's the person who won. But the most interesting is trial by ordeal. Trial by ordeal came in several different manners. But basically it was asking someone to do something, and then the result of that would determine on how favorably God viewed that person's involvement in the action the person had been accused of. So different kinds of trial by ordeal. Trial by fire. Trial by fire has certain forms, but basically it meant not that a person had to survive a full-scale fire, but maybe the person had to walk across fire for a certain amount of time, or had to hold a firebrand, a piece of wood, from the fire for, say, 5 seconds. What determined whether the person was guilty or not guilty was not the ability to hold on to the fire or walk across the fire. It was what happened afterwards, their ability to heal. Because if the wound festered, that meant God did not look favorably upon that person. And then that person was guilty if the wound festered. If the wound healed, then praise the Lord. That person then was taken care of by God, which had to mean that person was innocent. So that was one form of trial by ordeal. Also, and we all know about this, it was especially during the Salem witch times in the colonies, trial by water. A person would be tied in the fetal position and then thrown into the water. It's kind of a myth that if the person sank and drowned, that they were then innocent. Well, the person, if they sank, they were considered innocent. But they were not allowed to drown. They were pulled out of the water if they sank. And if they floated, well, they must be a witch, or they were guilty, or they did something like that if they floated. You know, it really had to do with body mass more than anything else. So people who had the body mass that was inclined to sink were disproportionately found not guilty. Now, here's some of my favorite was the ordeal by the cross. What ordeal by the cross involved, a few times that both the accuser and the accused were paired off against each other. So what would happen with ordeal by the cross is the accuser and the accused would have to hold up their arms in the symbol of the cross, and whoever let their arms fall first would be the one who was in the wrong in that particular case. They finally had to do away with that because they kind of made a mockery of Jesus Christ. The other church-related one was the ordeal by Eucharist. Ordeal by Eucharist. So a person would take a solemn oath that they had not committed the offense. And then they would take the body of Christ into their mouth after taking the solemn oath. If they were telling truth and taking that solemn oath, then they were fine. But if they were lying and they were actually guilty of what they were accused of, within a year they would die. That's what ordeal by Eucharist meant. Of course, it may have had more to do with if the person thought they were going to die in a year, they probably would be likely to die in a year. The mind kind of works like that. But the church also did away with this one because they felt it made a mockery of the Eucharist. So when the English folks came over, they settled the colonies, and the colonies had to have their own laws in place, and one of the laws that came over from England was the idea of having a grand jury system. And also, by then, we had a jury system in place. I'm not going to really touch on the evolution of the jury system. I'm just focusing on the jury, grand jury. So in the United States, in the colonial times, we already had grand juries, and these grand juries were fairly independent. One of the grand juries during the time of the Stamp Act upset the English officials because that grand jury refused to indict or charge people with violating the Stamp Act. It was part of that whole throwing gasoline on the fire of the American Revolution. So we had that in the colonial times, and in our Constitution. It was not in the original Constitution, but it was in the Fifth Amendment to the United States Constitution in the Bill of Rights. So here's what it says in the Fifth Amendment about the grand jury. No person shall be held to answer for a capital or otherwise infamous crime. Capital or infamous crime, it means something you could be sent to jail for more than a year. For more than a year. So in the United States Constitution, it says for any federal crimes, if you can be sent to jail for more than a year, that has to be presented to a grand jury. And there's always a provision for a person to waive their right to have it presented to the grand jury. But this was a requirement from the Fifth Amendment of the United States Constitution. And everybody knows the Fifth Amendment because, among other rights, it talks about the right to remain silent, the right not to have to testify in your own criminal case. A lot of good rights in the Fifth. So that's in the United States Constitution. Just because something is in the United States Constitution doesn't necessarily mean it would be in the Constitution or the law for all the states. And this is one of those things that is not required. It's required federally, but it's not required under state law. But the state of Texas has it in the state of Texas's Constitution in Section 10. Section 10 lays out generally all the rights of the accused in the state of Texas. And it says, no person shall be held to answer for a criminal offense unless on indictment of a grand jury. So what the Texas Constitution says, that any time someone is charged with a crime, it has to be presented, and the grand jury has to indict it. But then it gives exceptions. So those exceptions are for offenses for which a person could be sentenced to less than a year in jail, a year or less in jail. So misdemeanor cases are not required to be presented to a grand jury. They can be, sometimes they are if a grand jury is investigating, but typically they're not. They're an information file, and then the case proceeds to court. That's the formal charging instrument for a misdemeanor. But for a felony case, it must always be presented to a grand jury, unless a person waives their right to have it presented. Remember we talked earlier about the difference between felony and misdemeanor, possible punishment ranges. All right, let's talk about the Travis County grand jury system. All our laws relating to the grand jury are found in the Texas Code of Criminal Procedure, in Section 19 and 20 of the Texas Code of Criminal Procedure. It lays out how grand juries are selected, what their duties are, and all the rules relating to grand juries. So if you ever want to really bone up on it, really learn something about it, go look at Chapter 19 and 20 of the Texas Code of Criminal Procedure. So as soon as we became a state in Texas, we started appointing district attorneys. And we already had in the Constitution about the grand jury, but we needed to have district attorneys. So as soon as we became a state, we appointed district attorneys all over the state in areas where people live. So the first district attorney, so this is a guy named John Alexander Green. He studied at Winchester Academy, originally from Tennessee, like many Texans. People who became Texans were from Tennessee. He read law. Back then, you didn't have to go to law school. There weren't any law schools, there were very few. So you would read law, which is basically studying law. And he studied law with his father. So he studied law and practiced law in Tennessee. And then in 1845, he moved to Texas. Same time Texas was becoming a state. This guy volunteered in the Mexican War and served in Texas Ranger Company, really fought in the war. And he became a district attorney here in 1846. He became the first district attorney of Travis County. At that time, the district included Travis, Bastrop, and Fayette County. The district is a geographical area based upon population. Right now, the district is just Travis County. Back then, it included all three of these counties, and many districts were pretty large, but now most of the areas with large populations just have one county as their district. So at the time, John Alexander Green, he was the district attorney of these three counties, but it's just one district from 1846 to 1852. So something interesting happened soon after he became the first DA here in Travis County. The first politician was soon thereafter indicted. This is the sheriff of Travis County was charged with, and I know you can't really see that, this old document, he was charged in 1853 with gambling. He was charged by the grand jury with gambling. And he had been at some gambling house. I think it said he played Keno. I think Keno was the game he was charged with playing. So the grand jury indicted him for that, and he then had a jury trial. And you can see down here it says, we the jury find Scott guilty of betting on Keno. So he had a trial. He was found guilty by a jury here in Travis County in that same year, and he was fined $15 for his offense. So history is silent as to what his political persuasion was, but you can bet that he immediately said, this was a indictment brought against me because of my politics. Okay, how are grand juries selected? Okay, this goes back to Chapter 19 of Texas Code of Criminal Procedure. For most of the history of Texas, this is how the grand juries were selected. You can have a regular jury selection, or you can have this method. It's up to the judge to decide. And most judges chose this method that we call the commissioner system, or people have derisively referred to as the pick-a-pal system. The judge appoints 3 to 5 people to perform the duties of grand jury commissioners. Those commissioners then choose a broad cross-section of people based on race, sex, and age. This is what our Code of Criminal Procedure said they should go by. So the judge appoints commissioners. Those commissioners then select people to possibly be on the grand jury. And it's meant to be a very diverse grand jury. But that wasn't what happened. The judges selected commissioners, and commissioners basically selected white guys to decide if someone had committed felony offenses in Travis County. Happened like that for many, 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 many years, until there was a famous court case in 1940 called Smith versus Texas out of Harris County, and the court said that when it comes to Negroes, where they are intentionally and systematically excluded from grand jury service solely on account of their race and colors, it denies equal protection. It denies equal protection. What had been happening was that the judges would appoint commissioners, and those commissioners would select people that they knew. And it turned out that those commissioners apparently did not know any African Americans who they felt should be on the grand jury. You saw it over and over. And you go back and look at the transcripts of the hearing they were having on that, and the people being questioned, the commissioners, would often say, well, I only knew one black person, the shoe-shine person down the street. I didn't know him well enough to nominate him. I talked to Joe about somebody. He said he didn't know anybody. So they were basically, their defense was, I didn't know any African Americans, so I didn't nominate any African Americans. The court says, well, the only reason you're not doing this is because of their race, and that's what the numbers show, and we're not going to allow that. So based upon this court decision, everyone had to start making more of an effort, which meant that either the judges had to appoint people who were going to make an effort to go out and broaden the type of people they selected to serve on the grand jury, or else the judge would have to appoint African Americans as grand jurors. So where did we go from there in Texas? This is a grand jury from 1951. 1951. It is atypical for grand juries at that time. The law had changed, so there was starting to be more in there. But even in Travis County in 1951, you can see there are one African American grand jury on here and one over here. Lalo Campos, a Mexican American grand juror on there, but still no women on there. Still no women. So that's in 1951, and it's just a closer-up shot of it. Here's 1952, which is a year later, but typically how grand juries were still looking even back during the 1950s. Even though that Smith case had come down in 1940, there really wasn't that big a change in grand juries. Back then, the grand juries didn't meet very often because there's a smaller population in Travis County, so there's less crime being committed. They might meet once every 3 or 4 months to decide on whether to indict a whole whatever case that occurred during that time. Didn't meet very often. There was just one grand jury in effect. I thought this was interesting. You can't see the highlight. One of the persons on this grand jury is Walter E. Long from Lake Long. So you often have these upstanding citizens on there. Also, Jake Hirschfield is also on there. Over by the courthouse, there's a Hirschfield house that is a A&M property. It's a nice house over there. Hirschfield family own that, just big names in Austin. I want to talk to you about Jane McCallum. Jane McCallum served as a president-elector in 1940. 1940, one of the people sent to vote on the presidential election. She also was a state Democratic committee woman in 1942 and Austin's first planning commissioner in 1944. And most significantly, in 1954, she became the first woman from Travis County Grand Jury commissioner. Not to serve on the grand jury, but to be a commissioner. Because you can imagine what happens once you broaden the types of commissioners that you have. All of a sudden, magically, your grand juries start looking like this. So this is in 1957, just 3 years afterwards. See, already there are several women on the grand jury. Grand juries typically have 12 members, a couple of alternates, and often on the pictures, the sitting DA in on the picture. So if you see more than 12 up there, that's because of those added numbers in there. So in addition to judges starting to appoint here in Travis County, women, in addition to men, they also started appointing African Americans. They also started appointing Mexican Americans and also Asian Americans. So our grand juries are starting to look like this, where you have a diverse, wide variety of folks on the grand jury. Every grand jury is not as diverse as this grand jury. This grand jury, I thought, was interesting in that there's only one Anglo on this grand jury. That's unusual, but it's a reflection of what the judges in this county had always done in recent history, which is they make an effort to seek out a wide variety of commissioners from all over the county, of different races, different sexes. And those commissioners will do what they're supposed to do, which is bring in a wide variety of systems. So you had very diverse grand juries here in Travis County over the years. Everybody was making an effort, especially the judges, on reaching out and trying to make them more diverse. But things have changed on how the grand juries are selected. Remember back historically, there were two ways of selecting grand jurors. There was the regular way you have of selecting a jury where a whole bunch of people show up. Have any of you ever served on a jury before? A pettit jury? Yeah, so you show up with a crowd of people and then they do jury selection, and then 6 or 12 of you remain, depending on whether it's a misdemeanor or a felony. That was how grand jurors were also selected. But they had to serve for a longer period of time. We'll talk about that in just a second. So then the second way was the commissioner system that we just talked about, where the judges would appoint 3 to 5 people, and they would go out and get 3 to 5 people each, and they would make up the grand jury. So effective September 1 of 2015, the legislature changed all of that. The judges no longer appoint commissioners. Judges no longer have the authority to do that. Now the way grand juries are selected is basically the same way regular juries are selected. One thing that we know, based on experience, is that in the past when judges have used this method, as opposed to using the commissioner method, when they've used this regular jury selection method, the grand juries are just as good as any other grand jury. But the problem is those grand juries tend to be not very diverse at all. For a variety of reasons, those grand juries tend to be almost all Anglo grand juries. I think they make great decisions every time, but the question is, does that give your community faith in the grand jury? Because I don't think you want a system where you have the minority community looking at the grand juries that these just a bunch of white folks making decisions that affect our lives. We have no say in that. I'm not saying that those grand juries ever made bad decisions. I'm saying that from a community perspective, that may not be the best way to do it. So therefore, most judges in Travis County, even though they had this option, had selected other options, had used commissioner system, because they could appoint African American, female, Asian American commissioners who would make sure there were diverse grand juries. But now the only way grand juries can be selected is this method. So it will be interesting to see, and we just started selecting with this method, of course, in October is when we started. In October, we will start using this method because that's the next term. Okay, what qualifications does a person have to serve on the grand jury? Must be a citizen of Travis County. Again, we're only talking about Travis County grand juries. We're not talking about federal grand juries. Travis County. You have to live in Travis County. And you have to be able to vote. A person doesn't have to be registered to vote. They have to be qualified to vote. Must be of sound mind and good moral character. They typically leave it up to the person to decide if they are. Must be able to read and write. Notice it doesn't say read and write the English language. It just says must be able to read and write. Must not have been convicted of a misdemeanor theft. Any kind of theft convictions. If a person has been placed on probation and successfully completed probation, that doesn't count as a conviction. But any kind of theft conviction, the idea being that if you have committed a theft and been convicted of it, you're not of good moral character to serve on the grand jury, or any kind of felony conviction. Must not at present be under indictment for anything. Must not be related by blood or marriage to anybody on that same grand jury. You would think that wouldn't happen very often, but very often we get a group down there, but there's a husband and a wife on the same panel of people that might be on the grand, or father and son, mother, daughter, and cousins all the time. You know. And then it talks about you can't have served within the last year on the grand jury. So those are the basic qualifications, no complaint outstanding to be heard by the grand jury you're sitting on. Okay, so in Travis County, because of the size of our population, remember back in the old days they had one that would meet every 6 months or so. Now we have 3 grand juries that are meeting all at the same time, not all at the same time, but all in panel at the same time, meeting for a 3-month period. That's the grand jury term. They all serve for 3 months. So the different grand jury terms are January through March, then April, June, July, September, then October and December. So the next term coming up is October through December. So they serve for 3 months, but they don't serve every day for 3 months. The grand jurors serve typically 2 to 3 mornings or 2 to 3 afternoons or some combination of the two. For instance, a grand jury might serve on Monday and Wednesday afternoons and then alternating Fridays. They don't serve all day. A grand jury might serve from 1 o'clock into 5 o'clock on Monday and Wednesdays, and then from 8 o'clock into noon on Fridays. But you can see a 3-month term is a pretty long period of time for anyone to serve, and then you meet several times during the week. Most working people who have a 8 to 5 job or 9 to 5 job aren't able to do these kind of hours. But many folks don't realize that grand jury service is just like jury service in 2 ways. It's just as important, but also it's not volunteer. It's actually mandatory. If you're called to do jury service, you can't just say I don't want to do it. You could say that, but the judge will come looking for you. But also with grand jury service, but judges typically give a lot more leeway to folks who aren't able to do grand jury service, because it could ruin your career, it could ruin your finances if you have to do that and you really financially can't afford to do it. So the general duties of the grand jury will inquire into all offenses liable for indictment. It means criminal offenses, things that are under the penal code. It can be anything that the grand jury has been informed of by the prosecutors who present cases or by any citizen. anybody can write a letter to a grand jury saying, I think there's some shenanigans going on in this particular area. You look into it. One thing I always keep in mind about the grand jury is an independent body. It doesn't work for the district attorney's office. It doesn't work for the judge. They're impaneled by the judge, and the law says that the prosecutors have to present information to the grand jury. But the grand jury is free to do independent investigations. It's free to follow what the prosecution says or not follow what the prosecution says. That's the way the system is set up. The grand jury can take evidence from any person they deem to be credible and launch an investigation on them. You sometimes see grand jurors kicking the prosecutors out of the process. We had it in Harris County a few years ago where there was a big investigation going on with some driving while intoxicated investigations, and the grand jury decided they didn't trust the Harris County District Attorney's Office. Asked the judge to appoint an investigator for them to do their own investigation, asked that the prosecutors not be allowed to even come into the room during any part of their investigation. So that's something that a grand jury has the authority to do. The way typically it works is that law enforcement agency does an investigation, then they get a warrant for a person's arrest, and then after they get the warrant for the person's arrest, they send the paperwork to the clerk's office here. The clerk's office sends it to the district attorney's office. The district attorney opens a file against the accused, and we review it, decide if it's legally sufficient, if it's factually sufficient, and then we review it, and then the Travis County District Attorney's Office representative, prosecutor such as myself, will take it into the grand jury and present that information to the grand jury. That's typically how information gets to the grand jury. But again, it's not the only way. All proceedings in front of the grand jury shall be kept secret. Remember early on when we were talking about the Earl of Shaftesbury's case, where the grand jury wanted to have it heard in secret. They didn't want to have it in the king's court. King initially says no on that, being allowed to question of the witnesses in secret. That is carried over even until today. The grand jury process has always been a secret process, not because the thing is trying to be hid, but it's for the protection of grand jurors. It's also to keep someone who may be investigated by the grand jury, but ultimately absolved from that investigation getting out there, because just the smoke of that investigation can lead to a person's investigation being ruined, especially when you're talking about smaller communities as opposed to large communities. But everything that goes on in the grand jury, anything transpiring in there, is supposed to be kept secret. In order for someone to be indicted, to be formally charged, an indictment or a true bill, it means the same thing. At least 9 of those 12 grand jurors have to agree. It doesn't take all 12. Remember, this is not meant to be a trial. It's more of a screening mechanism. So at least 9 of the 12 must agree, and they must find probable cause. If the person is being charged with and they have an actual jury trial in front of a pettit jury, the standard is much higher. In front of a pettit jury, the standard is going to be proof beyond a reasonable doubt, the highest standard under our laws. Who may appear in front of the grand jury? Whoever the grand jury wants to hear from. But basically, the attorney representing the state, any witness or the accused may appear in front of the grand jury if the grand jury wants to hear from them. The attorney for the accused may appear in front of the grand jury, but only under this very rare circumstance. That's if approved, if approved by the state's attorney, then the attorney for the accused. What the law tries to avoid happening is turning these grand jury proceedings into trials. And that's what it would do if you allowed all these people in there whenever they wanted to. This is what an indictment looks like in the state of Texas. Does anybody know why it's on pink paper? Does anybody know why it's on pink paper? Anybody? Because it's always been on pink paper. That's the only reason. That's right. And they're doing very well because there's a lot of indictments. This is going to let me finish. So the indictment basically says the who, what, when, where, and how. Basically what Job was looking for when Job was being accused of what he did not know. Coming up on the anniversary of the Sniper Tower shooting, happened back in 1966. Remember Charles Whitman went up on the tower, shot, ended up killing 16 people, and wounding a bunch more. He was then shot by officers McCord and Martinez, I think it was. You remember what happened? Does anybody know what happened after Charles Whitman was shot in the UT Tower? Anybody know? His case was presented to the grand jury. The case against the officers was presented to the grand jury because it was a homicide. It was intentional taking of a life. So that case was presented. Even though it was clear that the officers were justified, the grand jury had to say it was clear that the officers were justified. So no matter what kind of case, circumstances of it, in a case like this, it will be presented to the grand jury for the grand jury to decide. This is what the grand jury room looks like. Folks sit around the table. Prosecutors usually stand at that little blue chair there and talk to the grand jurors. The grand jury room is located over at the criminal justice system at San Antonio and 11th Street. Where's I think my battery? Give me just 1 minute to get the battery right, and then we're going to finish up.
Question while you're...
Absolutely.
All right, we have an eager questioner back here, Richard Halpin.
I am an eager questioner. First of all, thanks for doing this. It sounds like a tough job, and it's awfully difficult to be fair all the time, and it must be difficult to do that. So thanks for doing that. And it looks like you get a sense of humor out of it too. So that's cool.
It helps survive the days.
We've heard over the last several years more and more people being put in prison, and they're innocent. And so I wondered if the grand jury has any mechanism to kind of rethink things and make sure that the people they're indicting are worthy of being indicting, and kind of stop the innocent from getting hung up and prosecuted in the process.
Now, always keep in mind what the role of the grand jury is. The role of the grand jury is to decide if there's enough probable cause to have the case proceed forward. The grand jury is not making any decision about whether the person is guilty or not guilty. The grand jury typically is going to hear only a limited amount of evidence. So I don't think there's anything about the grand jury system that would change that. I think it's a societal issue. You see a lot of people being exonerated because of DNA evidence, but also you're going to see less people being initially found guilty where they're innocent because of DNA evidence. So if all that DNA evidence had been present before that technology had been available, those people likely would never have been in there in the first place. Likely. I mean, there's going to be some, unfortunately, because you're dealing with people, some injustices done no matter what kind of system you have.
We have a question here from Gary Bennett. Gary?
Yeah, I just wanted to know when it was put into the Texas Constitution that the district attorney and members of the grand jury had to be the same political party as the state officials that they were indicting.
Interestingly enough, the Constitution and no Texas laws say that. But there's always that complaint.
Well, I have a question. What have you found to be the biggest challenges of working as assistant district attorney?
I think the biggest challenge is just some of the kind of crimes that you have to deal with. I prosecuted child abuse cases for 4.5 years, which I found the most gratifying thing I've ever done in my life, but very, very difficult in that what you're dealing with are kids who have been physically abused by people who should have been loving and taking care of them, or who have been sexually abused, and no matter what the outcome of the trial is, it doesn't fix the child that's been damaged, and it has I think a rippling effect, in that child is damaged, and kids who have been sexually abused or physically abused are not necessarily more likely to physically or sexually abuse other kids. That's somewhat of a myth, but there is some damage they will always carry with them, and so that's hard. I know it's hard for them to deal with it a lot more than it is for me, but that's the most difficult part of my job, is having to see that.
I'm sure. Do you want to take just 2 or 3 minutes and give us a final summary of it? I don't see any more.
So some of the benefits of being on the grand jury is that you get a good prime parking spot right by the courthouse, always reserved, U.S. reserved grand jurors, and you also get a very, very small amount of pay. Right now it's at $40 for each day you serve on the grand jury, each day you show up on the grand jury. It varies because it depends on how much the state is willing to contribute to it and how much the county wants to contribute to it. Okay, the final episode of Perry Mason, 1966. There have been 270. This is 271st episode. It's called The Case of the Final Fade Out. A judge who played in this, the only time he ever was on this, was a writer. He wrote about lawyers. He wrote about this character who was a prosecutor in California, this upstanding prosecutor who was always winning these cases against this shady defense attorney. He published a series of books about that, including his first book, which was called The DA Calls It Murder. And he appeared in this last episode of Perry Mason. Anybody know who this guy is on the right? No clue? Among other people who appeared in this last episode was Dick Clark. Dick Clark appeared in this last episode. But this person was Earl Stanley Gardner.
Oh.
He's the person who created Perry Mason. But he also had created kind of the alternative universe Perry Mason, where there's this prosecutor who was out there doing good, and there was this bumbling, stumbling defense attorney who he was always beaten. But before that, he created this, including this book called The DA Calls It Murder. So that is my trivia.
Well, Gary, we want to thank you so much.
Oh, my pleasure.
And, I think many of us were very uninformed about the grand jury. Generally there's no good way to find out information, so you have updated us, and we greatly appreciate it. I hope we're all going to be better citizens for this. Thank you, Gary.
You're welcome.
Let's give him a big hand.